Hello and welcome to Send Yes Leicester. Judicial review. What is a judicial review? Who can bring one? What does the process entail? And what are the possible outcomes? Judicial review is asking a court to look at the decisions of a public body and to decide whether it was made in a lawful, fair and reasonable manner. The court does not look at whether it agrees with the public body's decision, but looks at the way the decision was taken. If it finds that the way the decision was taken was unlawful, unfair or unreasonable, it can order the public body to remake its decision or order the public body to take a particular action. A judicial review claim may be necessary where there is no other way the complaint could be resolved. In relation to a child or young person with special educational needs, or SEN, this could be if a local authority, or LA, has agreed to issue an EHC plan but fails to actually issue the final plan, resulting in the child or young person missing special educational provision or schooling. The local authority fails to secure the provision set out in an EHC plan, resulting in the child or young person missing education. The local authority has arbitrarily or unreasonably decided to stop providing home-to-school transport to which a child or young person is entitled, meaning the child or young person cannot get to their place of learning. The governing body of a school refuses to admit a child or young person despite being named in the EHC plan, where there has been no formal exclusion. Failure to provide full-time education. Failure to provide the full national curriculum to children eligible to receive it. Failure to provide education out of school for children who for any lawful reason are unable to attend school. Unlawful exclusion from school. Refusal of local authorities to comply with special educational needs and disability tribunal decisions or directions. Failure to carry out annual reviews when due or to complete the annual review process within a reasonable period, and unlawful decisions by clinical commissioning groups to withdraw health provision in Section G of an EHC plan. This is not an exhaustive list. If the complaint is about the content of the EHC plan, then that should be appealed to the first tier tribunal, Special Educational Needs and Disability, or the SEND tribunal instead. In all of the above examples, the parent or young person should first complain to the local authority or school. Judicial review is only used where there is no other available effective remedy. For some complaints, it may be more appropriate or preferable for the parent to complain to the local government and social care ombudsman instead. You will need to consider which is the most appropriate way of addressing your problem. Procedure. The time limit for applying for judicial review is as soon as possible, but in any event within 3 months from the date when the act, decision or event being complained about occurred. It is usually necessary to show that everything possible has been tried to resolve the problem before resorting to court action. However, it is vitally important to apply for judicial review as soon as possible and within the time limit, even if the complaints procedure has not been completed. To succeed in an application for judicial review about special educational needs, parents must show either A. that the local authority or other public body does not have the legal power to make the decision or to take the action which they object to, or B. that the local authority or other public body is under a legal duty to act or make a decision in a certain way and is refusing or failing to do so. Public bodies can be challenged on grounds of illegality, including acting outside their powers or by making an error in law; irrationality, in cases in which a decision is completely unreasonable; procedural unfairness, including carrying out procedure unlawfully, breaching the rules of natural justice, failing to consider legitimate factors or considering illegitimate factors, and breach of the Human Rights Act 1998. Public bodies in education include local authorities, school governing bodies, governors of maintained nurseries, governors of further education institutions, independent review panels for permanent exclusions, admissions appeal panels, and government ministers and government departments. Getting legal help. Unlike appeals about EHC plans where parents are usually not legally represented, for judicial review it is strongly advisable to seek advice from a solicitor as soon as possible. SOS SEN can prepare pre-action letters, and you can find their details in the description below. The pre-action stage. The first part of judicial review is called the pre-action stage, where a formal pre-action letter is sent to the local authority explaining the issue and giving it an opportunity to resolve it. We would recommend getting a lawyer to draft this letter to ensure it covers everything it needs to. After that stage, an application is made to court for permission, known as the permission stage, to bring the judicial review. If you qualify for legal aid, this can cover the cost of a solicitor preparing the pre-action protocol letter. You can find out about legal aid in the description below. If you do not qualify for legal aid, you would need to cover the cost of a lawyer preparing the pre-action letter and making the application for legal aid for the child. We would recommend using one of the legal aid providers because if you can get legal aid in your child's name for everything from the application onwards, it makes sense for the same lawyers to do both parts. If you visit the legal aid website and select public law, then enter your postcode, you'll be able to find providers in your area. The permission stage. At this point, the claimant submits the relevant form accompanied by a supporting statement and relevant documents, including relevant statutory provisions. The bundle of documents will be considered by a judge whose job it is to decide essentially whether there is an arguable case, in which event permission will be given. If the judge refuses permission, it is possible to reapply for the decision to be reconsidered at an oral hearing in court. When asking for permission, the claimant can ask the court to make urgent interim orders, for example to reinstate SEN provision or school transport. In that event, the court may list the case for an urgent hearing to consider that issue. The judge considering the documents may in any event order that the case be listed for hearing. The full hearing. If permission is granted, the judge will normally make orders as to the timetable for the application, including the date by which any response by the defence must be entered and, in an urgent case, the date by which the case should be listed for hearing. Note that non-urgent cases are currently taking several months to come to trial. The final hearing will be in open court. Although children's details are very likely to be anonymised, it is very rare for witnesses to be called. Decisions are made on the basis of the papers and legal arguments. It is of course open to the parties to reach agreement at any point during this process, in which case a consent order will be lodged and the case will be brought to an end. Possible remedies. Quashing order. where the court overturns a decision and requires the public body to make it again properly. This is the most common remedy. Prohibiting order, where the court tells the public body not to perform an action or make an unlawful decision. Mandatory order, where the public body is required to perform an action, for example to ensure the help on an EHCP is carried out. Injunction, where the court tells the public body to do or not to do something. Declaration, where the court says that a decision or act is unlawful, for example a declaration that a decision or act is not in line with the Human Rights Act 1998. And damages, an order very rarely made in judicial review, but compensation may be awarded where a decision has caused harm or loss. This happens most often when a public body has interfered with human rights. The outcome. Appeals against the outcome of a judicial review can be made to the Court of Appeal with permission and again, if permission is given, to the Supreme Court. SOS SEN states, "It is worth noting that in our experience, over 90% of instances where we have sent pre-action letters have resulted in the problem being resolved without having to take the matter any further. If it is necessary to proceed to JR action, we will be happy to supply details of solicitors with legal aid contracts in education and public law and to liaise with them as necessary." Email us on info@sendiasleicester.org.uk. Call us on 0116 482 0870. Contact us on Facebook, which is Sendias Leicester, and you can also tweet us @SendiasL.